Jessica is the owner and lead consultant at Trial Dynamics. She graduated cum laude from Duke Law School in 2007. She received her JD and Master's in Psychology from there. And while there, she was trained by one of the nation's leading trial consultants, Dr. David Ball. She was given the privilege held by only a handful of people in the country of being able to study video of real juries deliberating from the Arizona Project. While at Duke, she spent 3 years studying juries, visiting courthouses, interviewing jurors, and interning with Dr. Ball. She trained in the art of editing opening statements and closing arguments to address the jurors' unconscious minds, thus making cases stronger by creating jurors who fight for your client when they are in the deliberation room. Jessica founded Hoffman Brylow Consulting in 2008, a full-service consulting firm specializing in plaintiffs' cases. Since then, she has expanded the firm to serve a wider range of cases on a national level. She believes that no two cases are alike, and that jurors respond to small nuances that make huge differences in verdicts. Consulting strategy techniques can reveal these subtleties and shed light on how to overcome hidden problems in the case, but only if conducted properly with attention to detail. I had the pleasure of meeting Jessica with a referral from my dear friend and one of my legal mentors, Ed Barad, who's a retired partner over at Brownstein. Jessica has since worked with us on a case, primarily with Ben Mueller, who helped, she was able to help Ben a lot with a very challenging and interesting situation. We're grateful for that. We're grateful that you're spending time with us today. Without further ado, Jessica.
Thank you. So my father is also a neuropsychiatrist in the area. He's retired, but I've sort of been psychoanalyzed my whole life. So I think it's sort of been a natural trajectory into this type of career. But when I was at law school, they did a one-day seminar on jury selection. And I thought, man, one day, that's a little short to be something that is going to have such a huge impact on the case. And so I started delving more into that because I always thought I would get a law degree and do something in business and that I would do focus groups for products. That's sort of where I was already headed. And so when he mentioned the name David Ball, which I don't know if you all know him, in the plaintiff's world, everybody knows him. And so he's the owner of the Reptile, which you may have heard of. And he lived in North Carolina near Duke. And so I called him out of the blue and I said, I'm a law student here. I think I'm interested in what you do. Would you sit down with me for lunch? And so he did. And he fortunately liked me and agreed to take me on as an intern with him. So while I was there earning my degrees, everybody else was doing law journal or moot court and things like that. And I was sitting at David's house working on opening statements, working on witness prep, working on focus groups, reframing cases. And that's what my training was. So following that, I came back to Colorado. This is where I'm from, and started up my own firm. And that's what I've been doing since 2007. I found that there's a big gap in family law, and I can't quite figure out why. I can't figure out why I didn't think of it sooner either. But for some reason, consultants are not permeating family law. And I can understand from the standpoint of, there's not much need for a focus group for your type of work, but there is a huge need for witness prep help. It almost matters more in your case than it might in other cases, because this is families that we're dealing with and children and lives and upbringings and things that matter, I would say, more than money does. And money's also on the line in addition to that. So to have a client who doesn't testify well, which I think comes up more often in family law cases than it would in other cases, because they're bitter, they're angry, they're getting a divorce. It's different than a car crash case where there may not be those issues. And so to be able to help in those cases, I feel like could make a huge difference in people's lives, in how the case would end up. So before I sort of get into this, is there, everybody's muted, but feel free to unmute yourself too. I just want to get a sort of idea. How often do you all do witness prep with your clients? What does that sort of look like? How much time are you spending on it? What are the troubles that you're having that you feel like you're not being able to conquer?
Well, Jessica, I'll just jump in by commenting briefly that we rarely do it in general. And the times, we're doing it in terms of prepping our own clients, as one of our lawyers, Niceta, is pointing out. But the rare piece where we're regularly doing it is where a client is going in for a child custody expert interview. We call it a CFI interview. And we find that coaching them for that particular kind of interview has been important. But other than that, it's not common.
Okay. Jeffrey, I saw you.
Yeah, the biggest problem I have is, and it may be virtually impossible to put a parent on the stand, is to keep them calm, cool, collected, and give, answers to keep them credible. So that's always a challenge.
Okay.
Jessica, I think it's hard too with our clients. One of the areas I most would appreciate help is getting them to focus, because often they want to tell a story that's not really helpful to what we need to come out, or that is, the issues they're upset about are sometimes not the issues we need the judge to know about. And so getting them to focus on the important stuff can be hard.
Okay. Andrew?
So, I always prep with all my clients. My issue is, while it certainly helps every time, it just seems almost impossible. Don't argue with the other lawyer, yes or no question. So getting them to stick to the game plan once we've practiced, it's difficult.
Okay. Anyone else?
Yeah.
Jessica, I've had a couple of instances now of clients who absolutely refuse to prep with me because of a negative prior experience with their previous counsel. Maybe their previous counsel wanted them to read a script or coach them in a way that made them uncomfortable. And I've never had a situation before until the last couple of years of having a few clients who would not prepare testimony, wouldn't even review questions. And as you might not be too surprised, their testimony didn't turn out all that well.
Yeah. Okay. All right. Let me try to screen share and bring up the slide. And if you have something to interrupt, please feel free to do that. I think some of the things that you guys all are mentioning is typical problems with witness prep. And I'll get into why I think some of that is happening, why they're not able to focus, why you might do the prep work, but they're still not quite getting it and it's not sticking, why they might be afraid to dive into that, and what can we do to get them to be more willing to do some of that stuff. So first off, why is it important that we do this witness prep work? It seems like there's a range from we do not a whole lot of it to we do it with every client, but depends on maybe what you're prepping for or how much time you might spend doing the prep work. And I would argue that it's important because there's a lot of people affected in your cases, right? There's the client on whichever side that you're on. There's the client's family that's involved, even extended family, children, and who's going to raise them and their upbringing, the estate and any money involved, and even you and your firm, your reputation and fees that you would get out of this. So why is quality witness prep so important? Well, I would say that's important because you as the attorney have the obligation to your clients to do everything in your power that you can to make sure that they have the best chance at winning. Of course, you can never guarantee a win, but you have the obligation to do whatever you can to make sure that their children and their families and their estate are protected. And if we have a bad witness, we've all seen cases before where you have great facts and then you have a really horrible witness. And often the bad witness can overcome all of those great facts. And the opposite is true too. You can have some really bad facts and have a great witness, and you can overcome those bad facts with a really good witness. So often it's the witness that matters more than the facts. And we see this in personal injury cases all the time as well, where I try to tell attorneys and clients, if you're talking to a prospective client and you feel like they are not going to turn out well when they testify, consider not taking that case. I mean, we can do work on them and we certainly can make them better, but sometimes that is the be all end all for the case. So it is extremely important to do really good witness prep so that you can get the most out of your client. I think that it's one of the most important elements of the trial. And if you are representing a husband in the case, they often start out behind anyway, just societal norms. They just start out with a little bit of a disadvantage in divorce and custody proceedings. And that might come off in their testimony as well, other than just the fact that they might need to testify even stronger. They might feel that pressure. And so that might affect how they are coming across in addition. So what's our goal? Well, our goal is that by doing effective witness prep, we can make a client who comes off as angry or bitter or anxious come off as grounded and strong and relaxed and open and vulnerable. And that can help the clients to win their case. So the timing of the witness prep does matter. Witness prep is essential for various points in your cases. It's not just for pretrial. So one time when I think it's very important is if you're going to have a guardian ad litem appointment coming up. In a child custody case, this can often be what sets the tone for the end result with the judge, because often the judge will take what the guardian says and just take that as true and run with it. So if your client isn't coming across well to the guardian at that guardian ad litem appointment, that can be the case right there. I think it's important to get to them before that happens, so that they can so that they can come across as honest and open and relaxed at those appointments as well. Before depositions, because depositions are a big part of what happens at trial. It will set the tone for what co-counsel or opposing counsel thinks is going to happen at trial. And they may lock them into certain written statements, but then having to deal with those written statements, at trial, if they have to disagree with it or anything, can be a problem. And so if we can get to them before depositions, that would be helpful. And then I often would say to do a pretrial refresher course. So if you have done some work on them before, they may not need to start from scratch, but a lot of this work is more like therapy than it is like attorney prep work. And so life hits them back in the face and brings them back down, and they just sort of need a refresher on how to reframe themselves so that they can come across well at trial. Sometimes I have clients, would be for larger cases where there's a big estate. They will sometimes give out my phone number to the client so that as daily life happens, they can call me and I can reframe it right then and there so that it's not just sitting with them for so long. So the problem with conventional witness prep is that most attorneys will focus on the external aspects, right? So where do you look and who do you talk to and what should you say and what should you not say? And sort of like we talked about, are you giving too long of an answer? Are you rambling on? Don't say that, stick to these facts. And it's not that that's not important, because there is validity to some of that. But the problem with it is that it's often ineffective, because if somebody is anxious about what they have to say, or they feel angry about what's happening to them, telling them to come across as not angry or telling them to not talk so fast when they're anxious isn't going to work. They just can't. They can't control it longer than a couple of minutes. So what we really have to do is to help them get through that so that they're not feeling the way that they feel, so they can testify in a different way. It also creates a problem that can backfire. So if you tell somebody to act in a way that is not how they're feeling, it will make them seem inauthentic. And to a judge or a jury, that is almost the worst thing that can happen, is if you have an inauthentic witness. So we want their demeanor to match what they're feeling internally. So with effective witness prep, we focus on their internal emotional state, which I've abbreviated as IES. If we can fix what they are feeling inside, that is what they will project through their body language and their affect and their words. So how do we shift what the client is thinking internally? Well, there's a little bit of a formula. So if you change the context, if you change sort of how they're thinking about the facts in their case, you can then change their internal emotional state, which can make them more likable, which can increase the probability of them winning. So if we start at the last step of winning, one of the most important of that is to make your client or your witness likable. Humans will judge facts through a story framework. So as you start giving facts to somebody, they create a web of where those facts fit, and they create a lens through which they then view the rest of the facts. So if you have a likable client, and then all these facts come out about the client, good or bad, the person will be more likely to accept the good facts about them because they like them, and they will be more likely to either change in their minds what they hear of the bad facts, or they will forget the bad facts ever existed. We see this all the time in jury deliberations where somebody who is pro-plaintiff against somebody who is pro-defense, the pro-plaintiff person will completely distort or forget the facts that go against their narrative. So judges are humans too. They can't get around their human nature, even though they might be slightly better at some of this than jurors would be. If you have an unlikable client, the juror is going to accept those unlikable facts, and it's going to make it worse. It compounds against itself when you start hurling facts at them. So another problem with that is, somebody mentioned that you have a problem where they might come off as sort of angry and still combative at being questioned. And I think the reason that happens is because we're focusing too much on their words, but we're not focusing on helping them through their emotions. So one thing that I'll tell clients often is that if an attorney is coming at you, it's actually a really good thing, because there is a thing called cognitive dissonance, which is a concept that means something is unequal. So if people see an injustice in the world, the human reaction is to try to make it justified, to make it equal, to balance the scales. So if we have a client who is acting authentic and is a likable person and they're getting attacked, the human nature is to want to save them and to help them. If the client themselves says, I'm being attacked, I better fight back, or if you as the attorney even fight back for them, you create that evenness. You and the client just made the scales even, because the judge can sit back as a human and human nature and say that justice has been done here. They're taking care of themselves, so I don't have to do it. So it's actually a gift if the attorney comes at your client. And by having them understand that can sometimes make them sit back and go, okay, I don't have to defend myself. That actually the judge will defend me, or the jury will defend me in their verdict, and I don't have to do it. So if you explain cognitive dissonance, number one, their behaviors and their words have to match, or they're going to come off as inauthentic and nobody will want to help them anyway. And we don't want to create an inauthentic witness by making them do things that are not in line with how they feel. But if we explain then cognitive dissonance, sometimes it will calm those witnesses down so that they're not as combative, because they'll understand that actually that's a benefit to them when someone comes at them rather than a risk. I think clients also need to understand that grief, sadness, vulnerability, those are all appropriate emotions, anger, but we need to get them to feel differently about their situation so that they can testify authentically and use those emotions in an appropriate way. It's okay to cry up on the stand, but it's not okay to look the whole time like you are being a victim. So there's got to be a balance there, and you can't achieve that balance unless you change their internal emotional state. So if we have an action and an internal emotional state, those are two different things, okay? So here's a pen. I can pick up the pen, and I can do it in a couple of different ways. I can do it where I'm angry and I can pick up the pen with anger. I can pick up the pen and be really sad about it. There's different ways to pick it up. So the action itself, which is also the words of the client, don't matter so much as their way that they say it and the way that they do it. I can say, yes, sir, in many different ways. I could say, yes, sir. I could say, yes, sir. Those are very different and they come off very differently. But in order to get somebody to change the way that they're coming off, we have to change the way that they think about it. So if you were to talk to your witness or your client, and some of you can feel free to unmute and chime in here, what do you think they would say, or what would you say are the emotional states that you want them to portray that would be consistent with winning?
Someone said sincerity, Jessica.
Yeah. Sincere, I would say calm, centered, vulnerable. If you ask them which ones they think are inconsistent with winning, they'll usually come up with things like being angry or defensive or bitter. And those are usually where your clients are at, oftentimes. So to try to win a case when they're feeling that way is going to be an uphill battle. So the question becomes, how do we shift that internal emotional state? Well, there are facts, and then there's the story that they make about those facts. So we have to focus on changing their story about whatever the facts are. We can't change the facts. The facts of the case are the facts. There's no way to change them. But changing the story about them can change how they testify about those facts. So here's an example that almost every client has. Almost every client has the fact, I'm in a lawsuit. And they almost all have the same story, which is that I should not be in a lawsuit. That makes them feel angry, bitter, defensive, all the things that you don't want them to feel. So we need to work on changing that story. So the fact is still the same, I'm in a lawsuit. But what if we cross off the not? I should be in a lawsuit. Well, how do you get someone to feel like they should be in a lawsuit? Well, sometimes it's about comparing what the alternatives are. So I've had a client who was from Somalia, and over there it's an eye for an eye, a tooth for a tooth. So he was thrilled to be in a lawsuit because he thought, what an advantage, what a blessing to be able to be in a country where I can right the wrong in this way. And so you can talk to your clients about, what are the alternatives here? I mean, the alternative is you're left to your own devices and you guys battle it out, which obviously doesn't work, or you wouldn't be here. The alternative is to do an eye for an eye. The alternative is to be left high and dry with nothing and not have a chance to work it out. So, you can look at it as a blessing or a curse. And if you can get them to see it as an advantage, that this is part of the system and that this system can work in their favor, some of that defensiveness can go away. Here's another example that we talked about a little bit, is when a fact is opposing counsel will ask questions with a mean tone. Yep, they might. And the story of that is usually they should not be mean to me, that they're hurting me and they shouldn't do that. And I'm a victim in this. And why are they being mean? I'm going through this hard time and, I don't deserve this, which is all valid. The problem is it's not consistent with winning. So if we can change that story and have the same facts, opposing counsel will ask questions with a mean tone, but the story is that they're just doing their job. The other attorney may not think poorly of your client, and they need to know that. The other attorney might think horribly of their own client, but they're doing their job just as you're doing your job. And so everybody has a job to do, and it's nothing personal. And then you can bring up the cognitive dissonance and explain to them that if they are mean to you, this is actually in your favor as long as you can keep your cool and stay even and grounded, that will actually help you out. And that can make them feel a little bit better when they're being attacked. Often you can even have them put a little sticky up on their screen if it's going to be over Zoom, or to have some reminder, switch your ring to the other hand or something like that, to feel like, to remind them that this isn't personal, that this is just part of the process and that they're doing their jobs. So I like to sort of move some of that into what I call safe harbor truths. And so every case has different facts. Those two examples are common to most every case that I would work on, but every case has different things that you need to work through the witness on, different stories that need to be shifted. And even just thinking about yourselves, you can sort of think, during COVID times, if things were rough, Did you feel like you were a victim of that? Or did you feel like I have the strength to work through this and I'm a survivor? So, you can have the same facts and you can think about them completely differently. And that will come off differently to people when you approach them. So your job as the attorney is sort of investigate what is hindering your witness. And it's different for every client and every witness. And it's really a digging job to find that. In the case I worked on with Ben, I won't mention case names since this is all recorded. But his client, was in a wheelchair and was disabled. And so some of the pain and the hurt and he had a victim mentality, which is understandable. I mean, he is a victim to a large degree. He was a victim, but that was coming through in his testimony. And so what we worked on was trying to make him see that he had strengths, that he was a good person because of how he had treated people in his life, that he was a strong person because, he has to live life in a wheelchair, disabled, and give up all of these things that he loved. And that takes a very strong person to wake up every day and to go through that. And so by working through some of those things with him to try to get him to realize parts of himself that maybe he wasn't seeing, he, as far as I knew from Ben, testified very differently than he would have otherwise. So when I do safe harbor truths, I like to try to condense some of those stories into truths that are safe harbors for them. I come up with maybe 5 to 7 max. You don't want too many or they can't remember them. But this is where you can create a more authentic witness. So everybody has something, usually, I guess not everybody, most cases have something where the client feels like they did something wrong. They need to own a part of it, or they're guilty of something in the case, but they're afraid to do that because they feel like that's going to hurt their case. So what you see during depositions and testimony and any guardian ad litem appointments is them being defensive or coming across as angry because they're trying to shield themselves from that truth coming out. And the problem is that shielding yourself from the truth coming out is worse than the truth actually coming out. And so we have to give them a safe way to own their faults, which makes them seem authentic and trustworthy, while still coming across as strong. For example, some witnesses feel worthless. We have to find out why they feel worthless so that we can then change the story and give them back their power. Some might feel betrayed. Why do they feel betrayed? And what can we do to shift that focus? For example, I worked with one woman who was in tears the entire session. She was completely in love with her husband, who was divorcing her, and the relationship had fallen apart over several years. They even tried bringing in a third person into the marriage. That obviously didn't solve anything. But she came off as very weak, and we didn't want that for her. So I had to delve into sort of, why did she choose him, and what was the background of that relationship? She had married him, she met him in high school. And, why did you choose him? And what was the relationship like back then? And what was her upbringing like before she even got married? So, I delve into things that you probably as attorneys aren't delving into. That's stuff that you wouldn't think to ask. The problem is you have to go there because you have to start figuring out and finding out what is it that's holding them back. So for her, she was actually less devastated about losing him than she was about losing who she was. So because she married him so young and she met him so young, she went straight from being a daughter to being a wife, to being a mother of an autistic child, to being a caretaker. And so when all of that fell apart, she was left with nothing. She had no clue who she was supposed to be or what she was supposed to do. So you could witness prep her and say, say this, don't say that, don't go into this, and hold back your tears. None of that's going to work on her. She can't do it because this is what's going on internally with her before you get to that. So, we had to go through, who were you as a child? What did you enjoy doing? What are some things that you still enjoy doing, take apart the way the husband and the kids, if they were gone and you had a week to yourself, what would you do? Do you enjoy cooking? Do you enjoy painting? Do you enjoy dancing? And I had to name things for her because she couldn't come up with anything. And she finally said, yeah, I do sort of like dancing. And, if I'm not taking care of someone, I sort of enjoy cooking. and had I had more time with her, see, I was contacted right before her trial, and so there wasn't much time to do anything other than to work on it for a couple days. Sometimes you need to spend a day with somebody and talk about their childhood and talk about their parents' childhood and try to see, where does this lesson come from? I mean, sometimes it's about their feelings about money. Sometimes it's about what their parents taught them about themselves, that they're not a worthwhile person. Once we could get her to sort of figure out the things that she liked and what she was good at, other than being a caretaker and a mother, what attributes did she have that were good, that meant she was a good person? I had her write all that down and put it all over her house. And so for a couple of days, she looked at that stuff. I did that the same thing with Ben's client and had him look at that for a while. And she testified with a calmness and strength that her attorney had never seen before. So had I had her from earlier, had I talked to her earlier, I would have said, sign yourself up for some dance lessons. Go take a cooking class, because to get yourself out there and start to feel like you are somebody other than a caretaker and a mother would have made her even stronger. So that's why I say you have to sort of back this up and not do it right before trial, because sometimes you need time to implement these things and get them through it. So if we can come up with some of those things and work them through it, then we can come up with some safe harbor truths. So for example, one could be a client that feels like they pushed their spouse away, and so they're partly responsible, for the divorce. So a safe harbor truth could be, yes, I did try to push him away, but that didn't warrant him cheating on me. So that they can own the part that was theirs, but then still come across as strong, saying, yeah, I did that, but that doesn't mean all the rest of what you're trying to infer. Another example is a husband might feel like they were hurting their kids by filing the divorce, or that they feel guilty, and they might come across as angry being in this process because they didn't want to go through all of that. And they could say, I had to go through this process because it's what I had to do for myself, but that doesn't mean I don't love my kids. Sometimes they'll come across as angry at somebody else because they're mad at themselves. And so you have to get to that. If your client was the one who cheated, they can say, yep, I cheated. I completely regret it. It was not the right thing to do, but that doesn't mean I'm not a great mother or father, that I still take great care of my kids. And so you have to find a way to frame it that they feel comfortable and safe, so that whenever they're being questioned about something, they have these 5 to 7 things that they can come back to say, when their words are trying to be twisted, that's not accurate. That yes, I did this and I have owned it, but that does not mean this other thing. So if you can get them that list, they have time to review it and they feel confident. That makes them come across as strong and very authentic. So, too often I see attorneys rush through witness prep. I think they focus on the facts and focus on the details of it without getting to what's behind those details. And sometimes that can it can help a little bit. I mean, clients do need to know where to look when they're talking, and, to look the judge in the eye, and that stuff is important. But I don't think you can get a good, authentic, strong witness by asking them to, just answer the question. Well, okay, we need to go through that. Here, when they're asking you a question, this is all that you're supposed to answer, is just the question. But their anxiety over what the story they need to tell is still going to come out. They're going to still keep pushing that if you don't tone down the anxiety. Or telling them, don't snap at the person who's questioning you without dealing with why they're snapping may not work when they're being really triggered. So it takes this kind of work, which can sometimes be done. I mean, I worked with Ben's client for 2 hours. So sometimes it's a couple of hours and we can make really good headway with the client. Sometimes it might take a day of really delving into who they are and why. In the instance of, being afraid to talk to you and even do witness prep with you because of past experiences, it may be helpful to have a third party like myself in there who's not the attorney, to sort of open up that door and say, this isn't really what we're trying to do. We're not trying to, make up words for you or tell you exactly what to say. We're trying to do the exact opposite, and to really get at what you're feeling about this so that we can help you through this. I think it's hard for clients to feel like putting out the money. I saw one comment in there early on about, one reason we don't do a lot of witness prep is because the clients can't afford it. And I get that. I completely get it. And in those situations, it may be that, a 1 or 2 hour session would be helpful. And you do what you can on your end, to prep them. But I would also say, what are they willing to afford to lose? Because if they don't come across good, not having spent $500 on a couple hours of help, they could lose their entire estate and their kids. So sometimes it's about trying to ensure that you don't lose what you have by spending a little bit more money and time to do that. Try to do what you can as well with them. That might take away from some of the time that I need to spend with them. If you can sort of get to some of this yourself, you can make a difference in them without me. But I think somebody has to be talking to them and spending more time than just, here's what you should say or not say. And with that, I'll open it up to questions, and I'll try to exit out of this screen sharing so that we can all see each other.
I have a question. In terms of witness prep, do you work, I'm not sure how much information you need from the attorney ahead of time.
Mm-hmm.
And then does the attorney also participate in the witness prep so that the attorney can then remind the client? And then I have a second question. I was interested in your point about cognitive dissonance and what that means. And I'm just wondering how that applies to the behavior that attorney brings to a trial or a hearing.
Okay.
Of whether or not to attack.
Okay, so and remind me if I forget these. First off, yes, you would be present when I would do the witness prep, usually. Some attorneys want to hand the client off to me. My concern with that is that there's never been a case tried with attorney-client privilege with a consultant. Now, I am also an attorney. I am not a practicing attorney, and so I don't keep my license active. I have an inactive license. So I don't know what that would mean in terms of protecting it. Very, very, very likely it would be protected. I mean, paralegals are protected, other trial teams. It's just never been tried. So I'm hesitant to be the one to tell somebody to do that. The more important reason, I think, is that I don't know exactly what's coming at them. So I sort of need you there to do some mock witness prep with them at some point with me there. And I need you to hear what they have to say and their story, because you're going to need to know that to work with them moving forward. So that's the answer to that. What information do I need ahead of time? Not a whole lot. I mean, just a background of, this is what we're fighting about. This is the issue I see with the client. This is what we need help working through. This is where we are in the case. So not a whole lot. And in terms of cognitive dissonance and you being the attorney, so if you are in front of a judge or a jury, you look to the judge or the jury to feel if you have permission to go harder against the witness, if that's what you're asking. So if you look over and they're just being really evasive or they're being absurd, they're going to expect that you take a little harsher tone with them. And it's okay to step it up, to some degree in that way. If they are sometimes their evasiveness and stuff helps you. So you don't want to necessarily correct it all the time or come after them, because again, it can help. So it's really about feeling out how egregious are they being, and does this warrant me getting a little bit more frustrated and angry at them and coming at them a little bit more? Or is this something where I should sit back a little bit, be very neutral, present the facts and ask the questions so that the facts come out, and just let the facts speak for themselves so that the trier of fact is angry about it? Does that answer your question? Okay. Anybody else?
Jessica, I'll chime in a little bit just to comment on my experience with you.
Sure.
If I to utilize her services even more than I did, even being more prepared on some of the witness questions, especially cross-examination questions, would have even benefited more. But the time spent was actually uncovering areas that I wouldn't have gone there with my client. It just doesn't, either it seems personal or it's just not, doesn't seem relevant.
Doesn't seem relevant.
As
Yeah.
we're trying to get through all the facts. I got to get this much stuff in. We only got 45 minutes. I've timed this out. And so you're just, I really want my client to just answer what I've asked and not say anything else. And what he did that still. So he did what I needed him to do. But what Jessica brought out of my client was it changed his mindset for it. And that's where I think that you were going with your presentation, but his mindset changed from who he was as a victim to, he's the one that's been trying to do the right thing. He was the one that was injured. He's the one that's been taking care of his kids as best he can. Everybody's taking advantage of him, but he can still be empowered. And then that just came across as confidence and not that everybody was out to get him. And that this was, instead of so anyway, it changed. She reframed his, and then when I was working through questions, when his answers came a certain way, then she could reframe that too. So it was both reframing his answers, but more importantly, it changed his attitude. And he had that sheet of paper in front of him during the trial, and he remembered it. We talked about it before the trial, and that's what, it's like he didn't remember. Frankly, it was like he didn't remember anything I had said and everything that she had pointed out with the sheet, but that sheet gave him, it wasn't rocket science on doing his trial. He could recall the facts I needed out of him. And so it was almost the other empowerment underneath changed how he came across. So I would never have asked those questions about, how he's feeling or you do, but not in the way that allowed him to express himself, because we're always on the clock and we're always trying to get through things. And so it changed his trajectory as a witness was changed for sure.
Well, and I try to warn attorneys when I start working with the client, because I feel like if I don't give a warning, everyone's going to think the first, hour, 4 hours is all like, why is she doing this? Like, why am I paying for this time? She's just chit-chatting with my client and asking about his upbringing. Like, why are we doing this? And there is a purpose to that. Sometimes you don't even know where you need to go to find the information you need. So you have to start, very far back and sort of build a rapport with the person so they feel comfortable talking to you. And in there, you start finding the story and finding where they're stuck. And so I always try to prepare people. I'm not wasting your time or your money. I promise I'm not. I'm trying to get to where I need to go with them. Peter.
Along those lines, every once I usually do something similar, where I'm asking them questions and seeing how they respond to those questions, and then talking about how they might, alter their response. And every once in a while, I'll get somebody who'll say, after the trial, they'll say, we didn't prep. And so it occurs to me that maybe it's important to say some magic words that let them know this is a prep. Thoughts on that? Have you experienced that?
I haven't really, although I'm always brought in when it's very clear that it's a prep.
Right.
So I don't really experience that. And I think a lot of what I do in the front end doesn't feel like prep. But that's what helps me sort of narrow it into those major truths and get them an exact sheet that they can take home and work on, and homework to work on. Again, it depends on how early I'm brought in. When it's very close to the deposition or the trial, then all I can do is give them some affirmations to put up all around the house. But ideally, they have weeks to work on that, or months to start getting into classes or do things that they need to do to shift, who they are and how they feel about that. So as we get more into that, I feel like they feel like it's more prep. And certainly when we do some mock, cross exam and things like that, then I will jump in during that as well and say, you should refer back to truth number 2 on that, or here's how you can explain that, and so we do a lot of what I think you would see as normal prep as well. But in order to get to that, to where it's even useful, you have to do all this background work first.
Jen, back at one more thing. When my client would respond, you would ask him, instead of me going, you can't say that, we need to do something else. She would ask him, why did you say that? Where's that coming from? Mm-hmm. And then that somehow circled back around. So I learned a lot from participating with her too, but that still is just not what we do as attorneys when we're trying to get through it. And it changed my client. Going through that made more sense about where he was going, and she unwound it. So he was wound up about something. Jessica was able to unwind him or reframe him and refocus his energy, whatever that was causing the problem in the answer, and that's where it went. So
well, and the nice part about it too is if you can do enough of it with them and really work on it, it can change their actual lives, not just the trial. But to walk around the rest of your life feeling like a victim is no fun. No one wants to feel that way. So if I can help them just in life in general to feel better about themselves, that's great. I would love that.
Let me just add, Jessica, if I could. Ben did a phenomenal job on this case, and he's typically being humble about it. But your work was amazing. I mean, to give you all some context, our client had suffered a tragic assault and was paralyzed virtually from what, the chest down, Ben, for the most part. And the case was about maintenance. And so the guy had every reason to be angry at the world to begin with. Mm-hmm. And then you put in that his wife is now trying to get his money from the settlement and had committed adultery. And this was a very volatile situation. And the fact that it went well, we got a great result, Ben did, is really astonishing.
Thanks, Rich. Yeah, he was paralyzed. Basically, he kind of used his hands, but he was paralyzed from the chest down, and he was a mess, and he was still a mess through it, but he straightened himself out, and he was more centered, is the best way I can put it. He did a good job, better than I would have. I didn't even know where to begin kind of prepping him, actually. I mean, he was just kind of a volatile guy, and he wasn't, he was less volatile and more responsive after that. So good job.
And there were a lot of issues, if I remember right, about money being missing and trying to account for, him taking out money for who knows what. He couldn't remember what. Right. So there was a lot of those issues too, of how do we deal with this? And that was sort of one of those safe harbor truths of, okay, well, we need to own the fact that you don't know where this money went. I mean, you can't go in there being defensive about, this is a bad fact. We have to own this so that it looks at least better. And then, say, but this is the type of person I am. I would not have put it toward X, Y, or Z. That's not who I am. That's not who I've shown to be in life. And so I can't tell you where the money went because I help people all the time and I might have helped somebody else with the money, but I didn't splurge it away. Look at where I'm living. He's in this old rickety house. I didn't spend it on myself. So we had to go through that as well to sort of reframe how he was going to come across about those bad facts. Any other questions or comments or concerns?
Jessica, I have a question or two for you. Mm-hmm. Any advice specifically for working with clients or witnesses who have unacknowledged serious addictions, whether it be alcohol or a case I have right now, which would be butane hash oil addiction? Didn't even know what that was until 6 months ago, as well as undiagnosed mental illness, self-medicating, or personality disorders. The fellow I have who has an unacknowledged serious addiction to butane hash oil is also a diagnosed narcissist in his parental responsibilities evaluation. I guess I don't think these are outlier cases. We just have so many cases with addiction, acknowledged, unacknowledged, mental illness, personality disorders, just really hard cases to help the people in their evolution as people, as well as the acknowledgement of their legal issues. Where would you dive in on all those?
Yeah, those are tough. It depends sort of on the person, how it goes. I think sometimes if you do enough work with them and spend enough time to build rapport with them, it's possible they would acknowledge it through the work if they feel like it's safe to do that and that doing that would help them and help the case. I feel like sometimes they feel like acknowledging that is going to lose them the case. But if the facts are all there anyway, and they're just not acknowledging it, that looks worse than acknowledging it. So I think sometimes getting them to see that might free up them to acknowledge it. If not, then all we can do is work around that and try to work on the other facts of the case and get them to frame it properly for them. I mean, are they still partaking in their child's lives? Are they still showing up to baseball games and still doing other things? So that, we can sort of work on the other facts and skirt around that, which isn't ideal. But if they won't admit it, there's not a whole lot else you can do with it. Anyone else? All right. Well, thank you all so much for your time. Kent, do I provide general therapy sessions as well? No, I do not. I'm not qualified to do that, but my father could have. But
Thank you,
it's the legal
Jessica.
version. Yeah, thank you, Rich.
Sorry to interrupt. That was a really fantastic presentation. I learned a lot. And
Good.
we appreciate your time
today,
and we appreciate the opportunity to get the CLE credit.
Yeah.
Moving forward, Jessica, is the best way for folks to get in touch with you if they want to via email?
Email or phone. Yeah, so it was on the slides. And if you want to send me an email, if you want the slides, I'm happy to send them to you as well. So my email, if you want to write it down, well, I can put it in here too, but then it's going to go away when we close out the chat. My
Right.
email is Jessica at trial, TRIAL, dynamics.net. And my phone number is 303-653-2233. And I don't work I work weekends and everything because I work for myself. So don't, if you've got a case coming up and you really need help, call me on a weekend. It's fine. But if you want the slides, shoot me an email and I'll be happy to send those to you.
All right. Well, thank you so much.
Thank you. Thanks for your time and your lunch hour.
You bet. Take care.